We're going to go ahead and get started. This is Intellectual Property Law 101 presented by Patterson shareholder Wayne Beavers. I'll hand it over to you, Wayne.
Thank you, Rob. Good afternoon, everyone. So our topic today is how to protect patents, trademarks, copyrights, and trade secrets. And we're looking at this basically from the standpoint of the general practitioner, and I'm trying to give you the basics and point out potential pitfalls and just things you should know in dealing with a client in the first instance to identify intellectual property problems they may have, whether you respond to them yourself or get them to someone else more experienced. But that's the level that we're going to go through this on today. So all businesses generally own three different kinds of property. There's real property, personal property, and then intellectual property. And you all know what real property and personal property are made up of. Intellectual property are things like information, technology, formulas, brands, designs, photographs, music, computer programs. Intellectual property is all these things that may have great value, but you can't necessarily hold them in your hand or lock them up. So we're going to look at four different types of intellectual property. We'll look at trademarks, and the basic idea about trademarks is that they protect source identification. Trademark law protects brands, whether it's a name or a logo, but it's something that functions as a brand. We'll look at the copyright law briefly, and copyright law is structured to protect original forms of expression. So if you write a book, if you write a movie, if you perform in a movie, if you write a computer program, if you take a photograph, those are different types of original expression that are protected by copyright. We will look at the patent law. And in connection with patent law, we'll talk about two types of patents. We'll talk about utility patents and design patents. Usually when you hear a reference to patents or patent law, we're usually talking about utility patents. So utility patent is the type of patent that protects a new machine or a new process or chemical compounds or electrical circuitry or things of that nature. Things and how they're made and how they work and what they do, that's the subject of the utility patent law. Design patents provide a very different type of protection. Design patents protect just the appearance of an article, and they cannot protect anything functional about the article. So design patents cover the non-functional appearance of the article. And finally, we will talk about trade secrets. And the trade secret law is basically a body of law designed to protect the expectations of confidentiality that a business has when it's dealing with its employees or persons outside the company. And we'll look at what situations you can expect confidentiality and what kind of material you can expect to be protected. So we're going to start with the trademark law. And trademark law is something almost every business runs into at one point or another because every business has a name. Most businesses have a brand. They may have many brands. To understand the trademark law, it really helps to understand the purpose of the trademark law. We've listed three here, but they really these three things are closely related. And the first thing that is listed, protecting the public from being misled as to the nature and source of the products they buy, that's really the key purpose of the trademark law. And we usually refer to this as preventing likelihood of confusion. So the key term in trademark law is likelihood of confusion. The entire purpose of the trademark law is to prevent a likelihood of confusion of consumers. The second purpose listed here is protecting the property rights of the business to identify itself and its products to the public. And then finally, protecting competition amongst businesses. But when you drill down into those last two reasons, it really still gets down to preventing likelihood of confusion of consumers. So let's go through some fundamentals of trademark law. The classic definition of a trademark is a trademark is a word, symbol, or device that identifies the source of a product. And if you think of it as a brand, you'll be fine. So since the purpose of the trademark law is to prevent confusion of consumers, we're going to see that trademark law is constructed around consumer perception of brands. So again, the test for whether two brands are in conflict is whether there's a likelihood of confusion of consumers. And this is, even though we look at a lot of evidentiary factors to reach this ultimate conclusion of whether or not there's a likelihood of confusion, what we're really trying to do is get in the heads of the consuming public, and we want to know if a substantial portion of the consuming public is likely to be confused by this situation. Another interesting aspect of a trademark is it also is a merchandising shortcut. You spend a lot of money to educate your customers about your brand, particularly if you have a consumer product like Coca-Cola. And we've all been taught that you see that Coca-Cola brand, you know exactly what you're going to get. You know the quality of what you're going to get. And we don't have to spend a lot of time in our shopping. We just reach for the brand. So the test for whether a given term can be protected as a trademark is whether it can serve as a brand to consumers. And here's where the concept of generic terms comes in. We say a generic term cannot be a brand. It cannot be protected as a trademark. And the reason is that when we say something is generic, what that means is it's the common name that consumers use for the product. And if everyone thinks that this term is just the common name of the product, then there's no way you're ever going to change that in people's minds. And so if consumers think it's a generic term, it's generic, and it can't be a trademark. On the other hand, there are a lot of terms that are not generic, but they tell us something about the product, and we refer to these as descriptive terms. They may describe some characteristic of the product. They may be geographically descriptive and tell us where the product came from. These terms can be trademarks. We say that these terms are not protected initially, but they're protected after we have educated consumers to recognize them as trademarks. And we do that education through advertising. And this new meaning that customers attribute to this descriptive term is what's often referred to as secondary meaning. So if you adopt a descriptive term as a trademark, it becomes protected when you achieve that secondary meaning. You often will also see reference to service mark, and we get the question, what's the difference between a trademark and a service mark? From the legal standpoint, there's really no significant difference. A trademark is a mark that's used on a physical product. A service mark is a mark that's used in connection with rendering a service, but the law is basically the same. It's very interesting to realize that there are a number of things that can be trademarks that a lot of people don't normally think about. It's far more than just a technical brand. We'll see that the trademark law can actually protect product shapes in some instances. It can protect packaging formats. The trademark law is also the primary source of protection for domain names. And one really important thing about a trademark as compared to other types of intellectual property like patents and copyrights is a trademark can last forever. We'll see when we talk about patents and copyrights that those are rights that are granted for a specific time. When that time expires, the right goes away. With a trademark, we have trademark registrations that have a life, but they can be renewed indefinitely. You can renew them over and over and over. So as long as you're using the trademark and it hasn't become generic, it's protected by the law. Here's one example of a product that we're all familiar with, and it shows us that a product can bear many trademarks. This classic Coca-Cola bottle shape, the shape itself is a registered trademark. Whether you call that a product shape or a packaging shape, it's a shape protected as a trademark. Of course, the Coca-Cola name is protected. I think their particular script is protected. Probably their red and white logo scheme on the label, although I'm not certain about that. When we talk about domain names, as far as legal protection, just think of them as another type of trademark. The fundamental protection comes from the trademark law. There are some rules that are specific to domain names. There are some procedures that are set up, such as the ICON, Uniform Dispute Resolution Policy, that give you unique forums for protecting domain names. But the basic legal principles determining their protection come from the trademark law. Here's some examples of trademarks. Of course, all words can be trademarks. Here's a list of a few that we've registered for clients. With a word trademark, the only issue is to make sure it's not generic for the product, or if it's descriptive of the product, then you have to prove secondary meaning. Logos are protected as trademarks. Any shape can be a logo. Here's another example of a product with many trademarks on it, and this is a great example of using trademark law to protect product design. This is the classic Gibson Les Paul guitar, one of their flagship products. I had the privilege for many years of representing them. And this product has 5 different registered trademarks associated with it. On this next slide, we show the trademarks as they were reproduced in the 5 federal registrations on these different marks. So you've got 2 names, Gibson and Les Paul. Then the lowermost figure you see is a drawing of the shape of the body of the guitar. So that body shape is a federally registered trademark. The middle right-hand shape is a drawing of the outline of the headstock of the guitar. So that headstock shape is a federally registered trademark. And then in the middle left, you have a bell shape. That's a little piece up on the headstock that covers the end of the truss rod, which is the strengthening rod in the neck of the guitar. And that bell-shaped truss rod cover is a federally registered trademark. So those trademark registrations on shapes of parts of the product provide very valuable protection to the product itself in many ways. It's not every product that you can cover with trademarks, but if you can, it is very significant because, again, that protection never expires. Another type of trademark, which is rare but is possible, is a sound as a trademark. NBC has a trademark registration on the three little notes that you hear when some of their shows open up on television. Microsoft has a trademark registration on the little bit of music you hear when Windows boots up. A really interesting trademark sound story is the Harley-Davidson case. Harley-Davidson tried to register the distinctive sound of a Harley motorcycle. And if you're a motorcycle guy, you know that Harley sounds different from everything else. It's sort of a ta-ta, 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 sort of a staccato beat. And that sound they tried to register. Now, they were not successful because it was held that that sound was a functional aspect of the V-twin motor that Harley-Davidson used. And a trademark is never allowed to cover the functional aspect of a product. So regardless of whether that sound was distinctive and recognized by consumers, etc., it was not protectable because if they had been granted protection on it, it would have effectively prevented competitors from building an engine of that type. And protection against copying of functional aspects can only come from the utility patent law, not from the trademark law. Another rare type of trademark is a color trademark. And here we're talking about the overall color of a product. Now, lots of trademarks have some color as an aspect of the trademark, and that's very common. But in rare cases, you can have the overall color of the product protected as a trademark. There's two examples given here. Owens Corning has a registration on the color pink for this fiberglass insulation that you get in rolls and you might roll out in the attic over your garage. John Deere has a trademark registration on that John Deere green color for tractors and similar products. And it's a rare situation where you can protect a color in this way. It takes a really strong proof of recognition by consumers, but it can be done. One thing that's really important about trademarks is to search a mark prior to adoption. So in the typical situation where you encounter a trademark question with a client is they walk in and they've got a new mark they want to use, and they typically say they want to protect this mark. Well, really the first thing that needs to be done is to search the mark to make certain that there's no conflict with prior marks. Today, searching can be done very thoroughly and very cheaply. You can get a professional search done, reviewed with an opinion by an experienced attorney for something on the order of $1,000. And as you all know, in legal services, that's not much money. And it can prevent a lot of problems down the road. So once you've searched a mark, make sure there's no problems. The next thing you want to think about is registering the mark. And here we're talking about federal registration, not state registration. Federal registration, excuse me, federal registration of the mark is really important to protecting the mark. The registration is prima facie evidence of the validity of the mark and your ownership. You need the registration if you're trying to prevent someone from squatting on a domain name that incorporates that mark. The registration gives constructive notice to the world of your use of the mark, and that's really important as compared to the common law. Under common law, you can have multiple users of a mark in different geographic areas, but a federal registration cuts out that possibility and protects the mark for the first user. And there's a lot of increased remedies you can get if you get involved in litigation if your mark has been federally registered. You can take a federally registered mark to customs and you can challenge infringing goods being imported. Trademark registrations are important proof of your property rights, sometimes for financial reasons. I've seen a lot of financing deals where the bank takes a portfolio of trademarks as collateral on a loan. And just as a great example of the value of trademarks, people always talk about the Coca-Cola brand. And the number given here is that the brand is 75% of the company. I don't know if that's exactly right or if it's current, but the Coca-Cola brand is the most valuable asset that company has. So what is the test? What is the hurdle you have to get over to register a mark? The mark has to be something that's capable of being a trademark. Again, that means it cannot be generic for the product. And if it's descriptive, you have to prove that you've acquired secondary meaning. Then the second major test is the mark you're applying to register cannot be confusingly similar to a previously registered or previously filed application for federal registration. So when you file an application for federal registration, the trademark office will compare that to everything that's been registered before or that's been applied to be registered and is still pending. And if they think your mark is confusingly similar with one of those prior registrations, they will reject it. You have an opportunity to argue with them about that, but that's the process. We get a lot of questions about the symbols you can use with a trademark. You've all seen the symbol TM or SM or an R inside of a circle. TM and SM are just common law designations of trademark. Anybody can use those on anything that they contend is their trademark. More importantly, though, is the R in a circle designation. The R in a circle can only be used on a federally registered trademark, and that's after it's registered. It's not just when an application is pending. So after the mark is registered, you can use the R in a circle, and you should use it in connection with a registered trademark in connection with the goods for which the mark was registered. So that's all we're going to say about trademark law, and our next topic is the patent law. So we mentioned before there's utility patents and design patents. Again, utility patents cover machines, processes, all sorts of functional things. And as we said, design patents are kind of the opposite. They cover only ornamental, non-functional things. There's a third type of patent that we rarely get involved with called plant patents for new plant varieties. And we're not going to talk about plant patents today. So what is a patent? A patent is a statutory right granted by the federal government that gives the owner of the patent the right to exclude other people from making, using, selling, offering to sell, or importing the patented product or process. It's significant to realize that this is stated in the form of a negative right. It's the right to exclude other people from using the invention. Interestingly, a patent does not give the patent owner the right to make what's covered by the patent. It only gives you the right to exclude other people. So the way it works, if you think about there being a first patent on some fundamental product, and then a second patent on an improvement of that fundamental product. The second patent will be issued if it's a non-obvious improvement. But if the first patent is still in effect, and if it would be infringed by making the improved product, then the owner of the second patent on the improved product, even though they have a patent on it, does not have the right to make it, because if they made it, they would infringe the more fundamental earlier patent. By the same token, the party that owns the first patent cannot make the improved product because they would be infringing the second patent. So again, patents are framed as a negative right, the right to exclude other people. A patent is property, you can sell it, you can license it. Utility patents have a life of 20 years from the date they are filed. To get that complete 20 years, you have to pay taxes at 3 different times during the life of the patent. We call those maintenance fees. But if you pay them, the patent will last for a total of 20 years. Design patents last for 15 years from the date they are granted. So why do we get patents? Well, the most obvious reason that we want patents is to stop competitors from copying our products, to stop infringers. Quite often, an equally important result of filing an application for a patent is, while that application is pending, which is a process that takes at least several years, sometimes much longer, potential competitors, knowing of the pending patent, quite often will delay their entry into the market until they can see what the patent's actually going to cover. So a pending application, even though you cannot legally enforce it at that point in time, quite often is of great value, because your competitors don't want to gear up to make a product and then learn the next day that they have to stop making that product. I've seen situations where the patent application turned out to be a lot more valuable than the actual patent, because when the patent actually issues, people can look at it, and sometimes it doesn't provide very broad coverage, and a few changes can be made and the patent can be avoided. So the pending patent has a very great practical value in many cases. Okay, so what can be patented? We've already said for a utility patent, you can cover machines, processes, etc. But a machine or a product that has some new feature to it can be patented. Methods and processes of all kinds can be patented. They can be mechanical methods, chemical methods. They can be computer processing methods, methods of doing business using e-commerce platforms. All of these things can be protected as patented methods or processes. Chemical compositions and the use of chemical compositions can be protected by utility patents. So, how do we determine what a particular patent covers? If you look at any utility patent, at the end of that patent, you see a series of numbered claims, numbered paragraphs. We call those the claims of the patent. And each claim is like a separate patent. Each claim is a checklist. And to determine whether a claim of a patent is infringed by somebody else's product, we go down that list and we ask if every element is present. So if every element is in the accused product, it infringes. If you can leave out one element, you don't infringe. So we have a real simple example of a patent claim here, a claim to a chair. So this claim is to a chair comprising, and it has three elements: a flat seat having a first face and a second face, a plurality of legs extending from the first face of the flat seat, and a back support extending from the second face of the flat seat. So to infringe that claim, the accused product would have to have all of those features. So if the accused product is a stool with just a seat and legs and no back, it would not infringe. If it was a different type of chair and the back did not extend from the flat seat, but instead the back extended from the rear legs, then that chair would not infringe. So we look at every word in that claim, and every feature has to be there. Some practical considerations when you're talking with clients who are inquiring about patents. Number one, don't assume something cannot be patented just because it's relatively simple, perhaps. If it's new and it's valuable to the business, it's worth trying to patent it. If it's valuable enough to the business, it's worth trying to patent it. Particularly in the area of software, a lot of people assume that software can't be patented. Well, there's all sorts of difficulties in patenting software, but there are lots of patents on software-related inventions being issued every day. So if the client has a new product or a new process that's important to them, they're spending money developing it, don't assume that it can't be patented. Get it looked at by an experienced patent attorney. One real important issue in connection with patents is to understand who owns the patent rights in an invention. Our law starts with the proposition that the inventor, the human being that made the invention, is the owner. Now, if that inventor is an employee, the employer may be the owner. That will depend on what the employee's job is, were they hired to invent. It will depend on whether they've signed an employment agreement that says that their inventions belong to the employer. But if the inventor is not an employee, then you definitely have to look at contractual provisions to determine or to get the patent ownership where you want it. If a business hires an outside consultant, an independent contractor, to do inventive work, you need a written contract and a written assignment of patent rights as part of the consulting contract. If you do not have that, the business will probably not own the patent rights. What the business will have is a license, a limited license to use the patent rights. It's important to understand our patent filing system and some time deadlines that it creates for us. We, the United States, are now a first to file system. That changed just a few years ago. It used to be we were first to invent, but now we're first to file. So it's very important to file your patent application as quickly as possible. Also, if you make any kind of public disclosure of the invention before you file, then you have to file within no more than 1 year of that public disclosure. The United States and Canada and a few other countries have this sort of grace period, we call it. But it's also important to understand that most countries do not have a grace period. If you're interested in patent rights outside the United States, you should assume that you have to file your patent application in the United States before you make any public disclosure. So again, if a client comes to you with questions about potential patent rights, be aware that they could lose very valuable patent rights if they make any public disclosure before they've filed. So they need patent counsel, and they need them at an early stage of the product. For most foreign countries, if you make public disclosure before you've made your initial patent filing in your home country, you have lost the right to file in those other countries. So let's talk about copyright law for a little bit, and then we will finish up with trade secret law. So what is a copyright? Copyright protects works of authorship, and that's really any expression that's fixed in tangible form. So if you were recording this talk I'm giving, that is a fixation in tangible form of my expression. If you're writing on a piece of paper, you're fixing in tangible form your expression. If you take a photograph, that is a fixation in tangible form of expression. If you write music, if in any of these things, when that expression is fixed in tangible form, the federal copyright law automatically comes into play and protects that expression from copying. The only requirement for copyright protection is that the expression be original. And this is very different, for example, from the patent law. We didn't talk in any detail about the test for patentability, but to get a patent, you have to show that an invention is a non-obvious improvement over everything that's come before. And that can be a fairly high hurdle. But for copyright law, the test is just that the expression has to be original. And all that means is that you did not copy it from someone else. So it's theoretically possible for multiple people to have a copyright on an identical expression. It's unlikely, but it's theoretically possible. As long as none of them copied the others, then they each have a copyright in their original expression. There is the requirement that the material have some minimal creativity, but that is also a very low hurdle. There is a copyright registration process, but registration is not required to establish federal copyright. Again, the copyright protection comes into effect immediately upon creation of the material. Very different from the patent law. If you don't file a patent and file it quickly, you lose your right. That's not true in copyright. So you have your copyright whether you register it or not. But registration is important if you need to enforce your copyright. And fortunately, we'll see the registration process is very simple. So most companies that have important copyrights will register them. It's very simple to register copyrights. There are literally forms you download from the Library of Congress. You fill in a few blanks, you mail it in with a copy of the copyrighted work. There's a minimal filing fee. It's $20 or $30, I think, these days. You mail it in, and there's not a real examination. They just make sure it's all filled out correctly, and basically the registration is granted. Once you've got the copyright registered, then if you need to file a suit for infringement against a copier, you can do that. And the registration of the copyright at an early stage before the infringement occurs gives you enhanced remedies compared to what you would have if you wait. But you can, if you get in a situation where a work has been copied, the copyright has never been registered, you can come in after the fact, register it, and still at least file suit for injunctive relief. But your damages are much greater if you have the registration before the copying occurs. Another question that comes up a lot with copyright is about the copyright notice. Putting the copyright notice on articles that are distributed used to be critical. It's no longer absolutely required, but you should use the proper copyright notice on articles that are distributed. You're not required to have a registration in place. You should place the notice on all copies that you distribute. And the distribution of copies of a copyrighted work is what we call publication. So if you publish the work, you should put the copyright notice on all copies that you publish. And the copyright notice is the copyright symbol or the word copyright or the abbreviation, the year of first publication, and the name of the owner. And we've given several examples here of proper copyright notices. So what are the key pitfalls under the copyright law? This is similar to what we discussed about patent ownership, but it's even more critical with copyright. The particular pitfall with copyright is when a business hires an outside contractor to develop copyrightable material for them. And if you think about it, this happens almost every day. You hire an ad agency to create an ad. You hire a photographer to come in and take photography that you're going to use in the business. So these are non-employee, third parties, independent contractors. They're creating copyrightable works. They're being paid by the business, but unless you have a written agreement to assign in place, the business does not own the copyright. Again, what the business will have is a limited license to use the copyrighted work to whatever extent was understood when the parties contracted. So that's pitfall number one under the copyright law. Pitfall number 2 is the problem of unintentionally being a copyright infringer yourself. Copyright liability exists whether you know you're infringing or not. And again, let's look at the example where a business hires an outside consultant to create an advertising campaign. And let's say that the person at the ad agency who's putting it together needs a photograph of a tractor for their ad. And if they're a little lazy these days, it's real easy to find all the photographs you want of tractors. You just go online and hundreds of them will pop up. And so let's say that the copywriter at the ad agency pulls a photograph off the internet, puts it in your advertising campaign. And later on, the party who took that photograph sees it, and you've got a lawsuit on your hands. We've seen this happen over and over. So the takeaway is when you're creating works that include materials that you did not create yourself, you always want written releases, and you want to know where everything came from. If you don't have written permission to use that photograph off the internet, don't use it. Finally, let's talk a few minutes about trade secret law. So what is a trade secret? Well, we've got 3 general factors that we looked at. First is that it's something not generally known outside the company. Second is it's something that's valuable to the company or to competitors. And third is that reasonable measures have been taken to guard the secrecy of the information. Now, we're going to see as we talk about these in more detail, it's real easy to remember really what the key test is for a trade secret. It has to be secret. And the big problem with most alleged trade secrets is they're not secret. So let's look at this first factor. It must not be known or readily ascertainable to others. We look at general factors like these to determine whether the information is known or ascertainable by others. The first factor that's really important is you have to be talking about very specific information. You cannot just generally allege trade secrets. Many times I've had a discussion with a client who says, well, my employee has left and they've taken my trade secrets. They've gone to a competitor or they've set up a competing business and they've taken my trade secrets. So the next question is, well, okay, what is the trade secret they took? And the answer quite often is, I don't know. I taught them everything they know. They had to have taken the trade secrets. They took everything. Well, it doesn't work that way. And it's really important to understand that the law is very protective of the right of employees to move around. Every employee has the right to use their general knowledge and skill and experience and go set up their own business or go to work for a competitor. So you don't get away with the allegation of everything that guy knows I taught him, so he took my trade secrets. It just doesn't work that way. You have to identify the specific information. This has to be information that's not generally publicly disclosed and has been protected. The second column here shows a number of examples of things that can be protected as trade secrets. obviously technical information, process information, but a lot of business information like vendors and suppliers, sales and marketing. People always ask about customer lists, and yes, customer lists in rare cases can be trade secrets, but any information potentially is a trade secret if it meets the other test. We say that the information has to have independent economic value. We typically just look at things that would indirectly indicate that the information is valuable. If you spent millions of dollars developing it, presumably it's worth a lot. The most important thing we always have to look at in a trade secret case is, have reasonable measures been taken to keep the information secret? And there's no hard and fast rules on this. But the truth is, it's not that difficult. And it's not difficult to set up a very good trade secret protection program for a client. We do this all the time. You go in, you sit down with the business, you go through it, you figure out at what points in the business process do we have information that we want to protect. We don't want our competitors to have it. We don't want our employees to take it with them if they leave. You identify that, and then you say, what can we do to keep that from being generally known? If it's technical information, you disclose it to the employees who need it to do their job. You tell them it's confidential. You have them sign contracts saying it's confidential, and you keep it to the extent practical under lock and key so other people cannot get access to it. If the alleged secret is some formula for a material you're using in your process, and if that formula is stuck up on the wall next to the workstation where it's used, and if everybody walking back and forth to the cafeteria walks by that workstation, it's not secret. So it's a very practical sort of thing. We have a very new statute at the federal level called the Defend Trade Secrets Act. This is basically codified the trade secret law that all states already had at the federal level, gives you a federal cause of action, so you can go to federal court. One interesting new twist in the Defend Trade Secrets Act is immunity for corporate whistleblowers. If you think about it, your typical corporate whistleblower is disclosing information that the company wants to keep confidential, and they may be violating their contractual obligations with regard to confidential information. But the Defend Trade Secrets Act provides legal immunity to those corporate whistleblowers, and it preempts state trade secret law that might say otherwise. The Defend Trade Secrets Act provides very extensive remedies, all sorts of damage remedies, attorney's fees and costs, injunctive relief. So the Defend Trade Secrets Act is a real nice addition to our arsenal in dealing with trade secret problems. So we've got a few sources here for further information. You're all going to get a copy of these slides, and we're happy to answer follow-up questions that you may have later. Rob, have we had any questions come in while I've